out on the morning of September 25th, 2010.
What is your educational background?
Well, I received my bachelor's degree in chemistry from Brown University, go Bears, and then I received my master's and doctorate in forensic science from Johns Hopkins University.
Could you please tell the jury your professional background in breath and alcohol testing, please?
Oh, of course. I am a certified operator and a certified technician of the Intoxilizer 5000 and 8000. I was a member of the Midlands Department Forensic Team, and I'm also currently serving as the president of the American Board of Forensic Toxicologists. So yes, I have quite a bit of experience.
What are your trial experiences?
I've testified in over 100 cases in which a model of the Intoxilizer was used.
What method did you use to conclude Danny Dawson's breath alcohol content?
Well, today, or in this case, I use a derivative of Dr. E.M.P. Widmark's equation. Widmark developed an equation to determine blood alcohol concentration, but it was a very long time ago. So the reason I use a derivative of it is because we've had some developments in modern science since then that allow me to create a more accurate reading.
Okay. Is this a standard and well-known method in your field?
Oh, absolutely.
Okay. Walk us through the steps that you took for Danny Dawson.
Well, basically I had to work backwards. I reviewed the reports that were conducted by Dr. Smith, and I sat down with Danny Dawson, and we created a timeline of her drinking on the night of the accident. And from there I was able to crunch the numbers and come up with the blood alcohol concentration.
What was your conclusion?
My conclusion that Danny Dawson was around the legal limit, around 0.08.
May I approach you, President Counsel? Could you please tell the court what this is?
Yes, this looks like the breath test report from the morning of September 25th, 2010.
How did you come in contact with this report?
I reviewed it when making my calculations. It's standard for me to review things.
Is this an accurate copy to your knowledge?
Yep, looks like it.
Okay. You previously stated that you calculated Danny Dawson's breath alcohol content to be around 0.08. What is the prosecution Avery Smith results for Danny Dawson?
Well, she calculated that it was around, or the machine rather, calculated it was around 0.19.
So why are your results so far off from theirs?
Well, I used a very specific equation. I believe that my results take into account Danny's demographic as well as ethnographic features such as his age, his family background, his weight, and her gender. Excuse me, not him. Oh, I'm sorry, Danny.
Sorry, okay. Your Honor, I would like to present this as Defense Exhibit C.
Objection, Your Honor. They have not laid the proper business records predicate. Therefore, this is hearsay.
Okay. Sorry. I gave this to my witness. It was so he can review the case for Danny Dawson, and they provided it. It's your witness at Avery Smith.
Yes, that's correct. But if she wishes to put it into evidence, I still believe that the business records predicate needs to be laid.
It is authentic, that's true, but the business records predicate has to be laid for it to not be hearsay. So you do need to leave it predicate.
Okay. Tell us about the Intoxilizer 8000.
Well, would you like me to tell you about the Intoxilizer 8000 or this report?
I want to know about the Intoxilizer 8000, then we're going to get into the report.
Oh, okay. Well, the Intoxilizer 8000 has a lot of issues. I mean, I can calculate. There's mainly three things that I noticed. There's the errors within the machine itself. There's the human errors that can happen when they're conducting the machine, and then there's the ratio that the breath testing machine uses to convert to blood alcohol concentration.
Okay. Tell me about the report. So how does somebody come about to making this report?
Well, this report is spit out by the machine when when it is conducted of a breath test. It's something that's normally kept within daily business records, as it is what the machine uses, and so it's normally kept around to make sure that you can verify things.
Okay. So does somebody have to be trained to do this report?
Oh, absolutely.
And everybody in the field uses this report?
Oh, yes. This is standard for the Intoxilizer 8000.
Can I move to put this into Defense Exhibit C now?
I'm going to have to object again. While Dr. Ashley Norton can talk about the conclusions in it because it's part of his underlying facts and data, I don't believe that opposing counsel can publish this as evidence because Dr. Ashley Norton is not the person that actually keeps these records and is not the person that actually made it.
That's true. You can use the information in it, but the jury, it can be published to the jury, and you can refer to the fact that that report has been used, but nothing in it can be published to the jury.
That's fine. Okay. Can you tell us about the problems with the toxolizer 8000?
Oh yes, okay, so I stated earlier there were three main categories of problems. The first of the problems would be the errors within the machine itself. The second of the problems would be the human errors, and then the third of the problems would be the ratio.
What are the problems with the machine itself?
Well, the problems with the machine itself is that it's very sensitive. If the temperature is off by just a little bit, it can cause up to a 10% reduction, and the results are straying from the actual result, which can be very dangerous. Also, the machine has only been tested to 0.16 blood alcohol concentration. I heard Dr. Smith testify today that she had used it and seen a 0.35 result, which is very interesting because the National Highway Traffic Safety Administration has stated that this Intoxilizer 8000 model has only been tested to 0.16. So I'd be very wary of any results above that.
Okay. So in this case itself, what are the possible human errors?
Well, the possible human errors, the biggest thing is about the observation of the person before they take the Intoxilizer. Now, I heard Dr. Smith testify that Danny in the night of question was observed for 25 minutes, which is very strange because her report, first of all, marks that she was only observed for 15 minutes, and then there was no observer name marked on her report, which is also very suspect of something that we want to make sure that we keep very controlled access and very controlled records of when conducting these reports, especially with such a high reading. And also, Danny said that she wasn't asked about burping or belching, which is also very strange because those things can produce mouth alcohol. And what happens is that the Intoxilizer picks up the alcohol that's in the mouth as opposed to the alcohol that's already in the system, which can really skew the result. And in fact, sometimes if it picks up enough of the mouth alcohol, it'll just read out at a very high level and stay the same, which is probably what happened the night that Danny got tested.
Tell us about the ratio of the Intoxilizer 8000, how that can dramatically affect the results.
Well, the ratio used by the station to convert breath alcohol concentration to blood alcohol concentration is 2100 to 1. This means that in 2.1 liters of standard human breath, there is the same weight as in 1 cc of pulmonary blood. Now, this ratio, however, can be in fluctuation. It can be anywhere from 900 to 1 to 3400 to 1, depending on the person in general. That's why it's very important that I took in consideration Danny's demographic data as opposed to just using a standard ratio. Also, what can affect this ratio is the rate of ethanol elimination. Now, since it had been over an hour since Danny had had her last drink, this means that she was in the elimination phase of alcohol, which could lower the ratio.
What was your conclusion?
My conclusion overall was that Danny was, in fact, around the legal limit, around 0.08. She was not grossly intoxicated as in 0.19.
Pass the witness, please.
Ross? Good morning.
Good morning.
Now, regardless of all that you just talked about on direct, you don't believe that Danny Dawson had a BAC below 0.08.
Oh, that is absolutely correct. There is no doubt that Danny Dawson should not have been driving that night.
In fact, your own words, Danny Dawson was too drunk to drive.
Oh, that is absolutely correct. However, it is very important to note that Danny Dawson was around the legal limit. He was not as grossly intoxicated as 0.19.
Pass the witness.
No redirect, please. I ask that witness to please step down, please.
Thank you.
At this time, defense calls Ms. Danny Dawson to the stand. Will you please state your name for the court?
My name is Danny Dawson.
Where do you go to school, Ms. Dawson?
Well, technically, I guess I am a senior at Calkins College in East Hills, Midland.
How do you know Vanessa Sullivan?
Well, we met our sophomore year. We had the same major, so we had a lot of classes together, and we found out we actually had quite a bit in common.
Ms. Dawson, are you aware of why you're here today?
Yes, I was the driver in a car accident that killed Vanessa Sullivan, and I'm here to take responsibility, but show that I'm not a murderer and I'm not a monster. I just wish that I could trade places.
Miss Dawson, where were you on the night of September 24th?
Well, I rode with Vanessa to Midlands, and I was meeting them at Chaggy's around 7 o'clock to celebrate her 21st birthday.
Were you familiar with Chaggy's?
Yes, actually. The previous summer I had an internship in Midlands, and so I was at Chaggy's quite a bit.
Were you consuming alcohol on the night of the 24th?
Yes, I was.
How frequently?
About 1 an hour. I didn't think I was driving that night, so I wasn't too concerned about it, but I did, try to keep around 1 an hour.
Did you consume alcohol throughout the entirety of the night?
No, I didn't. When I realized that I had to be the one to drive because both Vanessa and Taylor were too drunk to drive, I tried to slow down.
How?
Well, I started ordering sodas, and whenever they had a round of shots come around, I just tried to get mine to be water.
So, Miss Dawson, what was the last drink you ordered that night?
The last alcoholic drink I ordered was a tequila sunrise.
And what was the last drink you drank?
A shot of green alcohol.
Why did you drink that shot?
Because I thought it was water, and I didn't realize that it was alcohol until I'd already taken it.
Miss Dawson, who planned to drive home that night, to the best of your knowledge?
Honestly, I thought it was going to be Taylor Hobson.
When did you, Vanessa, and Taylor leave Chuggy's?
We left about 12:45 a.m. Vanessa has a 1 a.m. curfew, and so we were really concerned about getting her home in time.
At this time, did you feel like you were over the legal limit?
Honestly, I didn't. I thought I was well below the legal limit.
But after hearing some of today's testimonies, what do you think?
I think that though I may have thought that I was under the legal limit, I just can't really argue it.
Miss Dawson, who ended up driving home that night?
I did.
Why?
Because I thought that I was doing the right thing. I thought that I was sober enough to drive, and I wanted to get Vanessa home in time so that she wouldn't get in trouble with her mother.
Which route did you take home?
Well, I took the route that Taylor Hobson directed me through the Canyon Road one.
And why did you take that route?
Well, we thought that we would be able to get away with going faster. Vanessa had a radar police scanner in her car, and we thought that there wouldn't be as many cops on the road, and that would be the best way to get her home on time.
Were you familiar with Canyon Road?
I was familiar with it.
Now, Miss Dawson, I understand this question may be difficult for you, but how has the accident affected your life since?
There's no way to quite describe the guilt that stays with you every single day. I do hope that her family will somehow find a way to forgive me, but it's just so difficult to forgive myself, in honesty.
From your perspective, what happened on the ride home?
Well, in the car, it was very loud. Taylor was very, very drunk herself, and kept reaching over me and turning up the music, and she was singing and she was yelling, and Vanessa was on the phone with her dad, and it was raining really, really hard, and as soon as we came around the Canyon Road curve, there was a deer that was coming out of the left side of the road, and in hindsight, I really wish I would have just taken on the deer, but at the moment, I thought it was a split-second decision, and so I swerved the car to the right to avoid the deer, and I started to go off the road, and so I went to get back on the road, and I overcorrected, and we started hydroplaning and spinning across both lanes of the road and hit a utility pole and a tree.
Miss Dawson, where were Taylor Hobson and Vanessa at the time of this accident?
Taylor Hobson was in the back seat, and she was very quiet, but Vanessa was in the right passenger seat that had hit the tree.
Miss Dawson, after the vehicle had hit the tree, who else was present at the scene of the accident?
Well, I got out of the car and I saw the neighbor, London Bennett, who had seen the accident. She was running down from her house to see if everyone was okay.
Did the Midlands police arrive at the scene?
They showed up just a little bit after that.
Were you administered any sobriety tests?
Yes, I think within like 10 minutes of the crash, I was doing sobriety tests.
And again, Ms. Dawson, how has this accident affected your life?
Well, I'm taking time off of school and to just get my thoughts together. My life is pretty much on hold until all of this gets sorted out, but I'll take responsibility, but I just need to show, I guess, that I'm not a murderer. I'm not. I made choices that in hindsight I wish I would have made something different, but I didn't realize.
I pass the witness.
Cross trial.
Morning, Ms. Dawson. Now, I know this is going to be hard for you, but I'm just going to ask you a few questions and get you off the stand as quick as we can, all right? Now, you mentioned a deer.
Yes.
I'm sorry, objection, Your Honor. Can I get to where I can see this washer?
You don't have to object, just go around.
Once again, I'm sorry.
You mentioned a deer with your counsel, right?
Yes,
And you swerved to avoid that deer.
yes I did.
But to be fair, Ms. Dawson, that deer wasn't even on your side of the road, was it?
The deer was in the left lane, but it was coming towards my side.
In fact, you aren't even sure that it was a deer, are you?
It was something. It was an animal of some sort. It looked like a deer to me, but I'm not 100% sure that it was in fact a deer.
All right, Ms. Dawson. Now you say you weren't drunk that night, right?
I didn't think so.
You said you had no choice but to avoid that deer.
At that time, it came out of nowhere, and I should have just hit the deer.
Now, I want to talk about all the choices you had on September 24, 2010. You arrived at Chuggy's at 2 p.m., right?
Yes, I did.
And you left at 12:45.
Yes.
We're just going to make a timeline. Okay, I'm going to start at 2 p.m. and it's going to end at 12:45 a.m. Okay? And we're just going to do a little point here for 12 a.m. All right? And every time we get to a drink you had, I'm just going to put a tally mark up there, okay?
All right.
Now, when you arrived at the bar, you had a shot with the bartender, isn't that right?
I did. I knew the bartender, Jordan James, really well, actually, and I just had an interview that didn't go so well, so we took a shot at it, too.
I'm going to tally that shot. Now, after that shot, you had 3 whiskey and ginger ales.
Yes, I was just reading a novel, so for about, I guess, 5 hours, I was reading a novel and sort of sipping on a couple whiskey ginger ales.
I tallied up those 3 whiskey and ginger ales.
Mm-hmm.
After you had those 3 whiskey and ginger ales, you had a beer.
I believe so.
You believe so?
I don't know exactly what time we're at, but I know I had a beer that night. So.
This is just from the point from 2 p.m. up until 12.
Up until 12, okay. Yes, when Vanessa and Taylor showed up, we started drinking again. That was at 7.
I'm going to tally up that beer. Now, after you had that beer, you had a whiskey on the rocks with dinner.
Yes, I was eating cheese fries. I had too many cheese fries.
I'm going to make another tally for that whiskey on the rocks.
Mm-hmm.
After you had that whiskey on the rocks, you had a shot and another beer.
Yes.
I'm going to tally up that shot.
Sorry, it's kind of hard to...
I know there are a lot, and another beer. Now, after you had that shot and another beer, let me think. 8, you had, if I'm not mistaken, another whiskey and ginger ale.
Yes, I know I had 1 an hour. So between 2 and, we could just count it up that way. That'd be the easiest.
Oh, we're not done yet, Ms. Dawson. That you had another whiskey and ginger ale, isn't that right?
I don't know what time we're at, but sure.
Ms. Dawson,
I'm getting confused on the timeline. I apologize.
oh, I'm just saying all the drinks you had between 2 and 12.
Okay. Yeah, I guess I associate them more with what we were doing, but yes.
I'm going to tally up that extra whiskey and ginger ale. Now, after you had that whiskey and ginger ale, you started feeling tipsy.
Was this around 12?
Did you feel tipsy at all that night?
Yes, it did.
Now, after you started feeling tipsy, you had a shot. You had a shot to celebrate with the band.
When I started feeling tipsy, I had one more tequila sunrise, and I decided that I would not be drinking anymore that night.
Well, before that tequila sunrise, you had a shot.
The shot with whom? With the band?
Yes.
Are you referring to the last shot of the night?
No, the shot before the tequila sunrise.
I'm sorry. I'm getting extremely confused with what you're talking about.
I'm sorry, Ms. Dawson. Let me try to make it clear. You had a whiskey and ginger ale that Pat Lawrence brought you, right? And then after that, you toasted to Good Mornings with the band a little after 12 a.m.
Sure. I know that I drank obviously too much, so we can just assume so.
So after you realized you drank too much, you had a shot with the band.
I didn't realize I drank too much until afterwards.
Oh, I'm sorry, Ms. Dawson. I was just using your words. After you had that shot to toast to Good Mornings with the band, you realized that you were going to be the designated driver that night.
Yes.
And after you realized you were going to be the designated driver, you ordered a tequila sunrise.
And this is what I was referring to earlier. Yes, I was feeling tipsy, and I ordered one more drink. I felt that I still had enough time to sober up. So that's at the time, that's what I felt was an okay thing to do.
Now, after you thought it was okay to order tequila sunrise after knowing you were going to be the designated driver,
That was at 12, yes.
that was a little after 12, you had a shot of grain alcohol.
I did not intend to have a shot of grain alcohol.
You might not have intended to have that shot of grain alcohol, but you had a shot of grain alcohol.
Unfortunately, yes.
So I'm going to tally up that third drink between 12 a.m. and 12:45 a.m.
I don't know how correct the 3 drinks between those two, but there were 2 drinks between those 2 at least.
Well, let's make sure we've got it correct, Miss Dawson. I don't want to misstate your words. You toasted to Good Mornings with the shot with the band a little after 12.
Okay, I see where you're going.
Okay, you're following me now? I don't want to get you wrong. Now, after you'd had that shot of grain alcohol, you got behind the wheel of the car.
Yes, I still at the time felt that I was well below the legal limit.
All right, Miss Dawson. You got behind the wheel of that car and you took Canyon Road.
That is the one that Taylor Hobson worked with me, yes.
And you sped down Canyon Road.
Yes, like I said earlier, obviously now taking the priorities should not have been to speed. But at the time, we were really concerned about getting Vanessa home in time.
And you sped in the pouring rain.
Yes.
In the dark.
It was very dark, yes.
Now I want to talk about all the options you had to get home. There is another route to Vanessa Sullivan's home, isn't there?
There is.
There are actually 2 main streets that you could have taken.
But that is not the one that we took.
I understand that, Ms. Dawson. I'm just talking about the other main streets that could have gotten you to Vanessa's home.
Objection. Opposing counsel is referring to subsequent remedial measures, which are measures that would have made the action less probable, and that is unadmissible under the Amendment's post evidence.
Overruled.
Now, there are 2 other main streets that you could have taken,
Yes, there are.
but you didn't choose to take those main streets.
No, we were still at the time, we were all very concerned about getting her home on time for a stupid curfew.
Those 2 main streets, they were more well-lit than Canyon Road, weren't they?
Yes, they were.
They weren't as curvy as Canyon Road.
No.
Now, before you left the bar, you could have taken a cab.
Yes, the cab driver, actually Sam Lyons, knows me pretty well. I've actually used Sam Lyons before. I assumed that if Sam Lyons felt that I was too drunk, he would have let me gone past. Though it's not his responsibility to do that. I assumed. But we also needed to get Vanessa's car to her home, and so that was another big reason why we needed to drive the car.
Miss Dawson, knowing that you had just had 3 alcoholic beverages, the last one being a shot of grain alcohol, within 45 minutes, you refused a cab.
I didn't refuse a cab. We decided that we needed to get her car home. Obviously, in hindsight, the car was not as important. But I still felt that I was below the legal limit. I did not feel that I was drunk, nor did Sam Lyons indicate that I was drunk.
I'm not asking about Sam Lyons. I'm not asking about what you felt. I'm asking whether or not you refused a cab after having a shot of grain alcohol, a tequila sunrise, and another shot all within 45 minutes.
Well, I answered yes. I should have decided for the group that we were going to take the cab. I should have. But at the time, it just seemed like I was doing the right thing by driving.
Now, all three of you had cell phones that night, right?
Mm-hmm.
Okay. You could have called for someone to pick you up.
We could have. I guess we just didn't think about that.
But you did.
No.
Now, while you were on Canyon Road and it was raining really hard and you were speeding, you could have pulled over.
Yes, I could have. If I felt that I needed to.
Before you even got on Canyon Road, you could have pulled over and waited that storm out.
We could have, but like I said before, if I felt that I needed to, I would have.
At any point during that storm, you could have stopped and called someone to come help you guys get home.
Well, I don't really know anyone from the area, but I'm surely the other two girls could have done that. But once again, if I felt that we were in danger, I wouldn't have done it.
Miss Dawson, you could have stopped.
You're right. And if I thought that it would have ended the way it did, I would have never done it.
It's fair to say that had you stopped, had you got a cab, had you called anyone to come pick you up, Vanessa Sullivan might still be here with us.
That is extremely fair to say. If I would have made one decision differently, this whole thing could have been avoided. But like I said, I thought I was doing the right thing. And
Miss Dawson, you could have stopped at any point during that night to avoid this accident. But the most important point is you could have stopped at that first drink.
I didn't know I would be driving.
I'm not asking whether or not you knew you were driving. Just asking, you could have stopped at that first drink.
And I would have.
Objection, at this point, opposing counsel is inserting sidebars.
No, she's asking questions that she's permitted to do on cross.
Miss Dawson, you could have stopped at that first drink.
I could have done a lot of things differently if I would have known how it would have ended up. If I would have known I would have been driving, I would have never been drinking.
Well, let's take it to when you knew you were driving.
Mm-hmm.
You could have stopped after that shot with the bandit.
Yes, I stopped with what I thought was my last drink as a tequila sunrise. When I still had an hour and I still felt that I was sober enough to drive.
All right, so pass it. Your Honor, at this point, excuse me, I'd like to preserve this as stated Exhibit B.
Objections? No objections.
So good.
Redirect, Your Honor. Ms. Dawson, on this timeline that the prison counsel has just drawn here, at which point did you realize that you would be the designated driver this night?
About 12.
Your Honor, I object. I preserved this demonstration so opposing counsel would not be able to write on it. Stated.
Yes, Your Honor. Ms. Dawson, again, at which point in the night did you realize you were the designated driver?
About midnight.
About this time.
Mm-hmm.
So, out of these drinks, how many did you drink when you realized you were the designated driver?
It would be to the tequila sunrise, because when I realized I would be driving home, it was when Pat Lawrence came over, and I ordered one more drink, and then I ended up having a grain alcohol shot that I didn't know.
So out of these 3 drinks, you drank 2 knowingly.
Objection, Your Honor, leading.
This is cross-examination, Your Honor.
No, it's actually redirect.
I'm sorry. Out of these 3 drinks, which did you drink knowingly?
2.
Miss Dawson, on the ride home, can you describe to the court again how the car went off the road?
Well, it went off the road when I tried to avoid. deer that was coming out from the left side of the road. When we were going down the curve, it was a pretty sharp curve, and it was dark, so I didn't see the deer until it was just too late.
Did you mean to crash the car?
No.
Did you knowingly crash the car?
No.
Did you intend to go over that?
No.
No further questions. Free cross round. Miss Dawson, your attorney just talked to you about the drinks you had knowingly. You knew you had that shot, right?
I didn't mean to have that shot. I didn't know that I was taking that shot.
Talking about the first shot with the band. You knew you had that shot, right?
Yes, I knew I had 2 of the 3.
And you knew you drank that tequila sunrise.
Mm-hmm.
And then after you drank that third shot, you knew it was grain alcohol.
Afterwards, yeah, I knew it wasn't water.
You knew it was grain alcohol.
And it turned out to be grain alcohol, yes.
And after knowing you had a shot of tequila sunrise and a shot of grain alcohol, you got behind the wheel of a car.
Once again, I did not feel that I was over the legal limit. If I thought that I was too drunk to drive, I would not have driven.
So I'm not asking about how you felt.
Mm-hmm.
Just asking about what you know. And knowing that you had had 3 drinks before you got behind the wheel of the car, you did it anyway.
I felt it was the right thing to do.
Pass. Free director.
Very, very brief.
Yes, sir. Ms. Dawson, what is the legal limit of alcohol consumption in Midlands? Objection, Your Honor. Lack of personal knowledge. Also, any knowledge Ms. Dawson would know of the legal limit would be hearsay, and she'd be making an improper expert conclusion. Your Honor, this is testimony by a lay witness, and she actually does have the knowledge to testify that this isn't any sort of scientific or technical knowledge, but something that she actually does know, and I can actually lay foundation as to how she's aware of this knowledge.
Lay the foundation.
Ms. Dawson, how is it that you were aware of the legal limit?
When I was younger, I had to take some courses about it, so I was aware.
What did they teach you in these courses?
That .08 was the legal limit.
And so, what is the legal limit in the state of Midlands?
.08.
No further questions. No reproach. May the witness please sit down.
You may.
At this time, if that's Justice Case and Chief, it's up to you whether you'd like to take a recess or go on to the closing statement.
If the parties want to proceed straight to closing statement, that works for me, but if you need to take a recess, I'm willing to do that as well.
If you don't mind, Your Honor, a brief 5-minute would be wonderful.
parties ready to proceed with closing argument?
Yes, Your Honor. Before I proceed with my closing, may I reserve time for my rebuttal up to 5 minutes?
You may.
May it please the court. The defendant was the designated driver. The defendant was the designated driver who drove drunk. Because the defendant was the designated driver who drove drunk, Vanessa Sullivan is dead. Because the defendant was the designated driver who drove drunk, Vanessa's parents buried their only child. September 24th, 2010. The defendant goes to a bar with Vanessa Sullivan and her best friend. The defendant had discussed being the designated driver tonight. She drinks anyway. She's having drink after drink after drink after drink. Whiskey, mixed drinks, beers, shots. You heard about how the defendant was acting. She was slurring, she was stumbling. She even spilled her drink on her server. Now she insists that she's okay to drive. She gets behind the wheel. Now she decides to start speeding. She loses control of the car. She's spinning across the road. She crashes into a tree and she kills Vanessa Sullivan. Members of the jury, we had some things to prove to you today. And we had to prove them beyond a reasonable doubt. Not beyond any doubt. When you go back to deliberate, we know you'll have some questions. We've provided you with answers to those questions. First, we had to prove that the defendant operated a motor vehicle and that she was under the influence of alcohol intoxication. She drank from 2 p.m. until the time she left, 10.5 hours later. And just 45 minutes before the defendant left the bar, she had 3 separate drinks, 2 shots, and a tequila sunrise. 5 minutes before she got behind the wheel, she had a shot of grain alcohol and she did it anyway. More than that, members of the jury, you heard that the defendant was so drunk that she got up on the stage and played the band's guitar until she was pulled off. Then she got behind the wheel of a car. Now she wants you to believe that she wasn't driving under the influence. To prove murder, the defense wants you to believe that we had to prove that the defendant purposefully or knowingly killed Vanessa Sullivan. The judge just told you we can prove that she recklessly killed Vanessa Sullivan. Now, she got behind the wheel after 11 drinks. Her server told you that. The prosecution and the defense have both called alcohol experts here to testify today, and they both agree the defendant was too drunk to drive. Does that sound reckless to you? 0.19. That's how high the defendant's blood alcohol concentration was that night. It's more than twice the legal limit. Folks, that's more than double. When a person acts recklessly, that means they take a risk that a law-abiding citizen would never take. A law-abiding citizen. That's a person to whom the law still means something. And that's that same law that you've been brought here to uphold today. The defendant took a risk that none of us would take on our darkest day. She could have taken a cab home. In fact, she was offered a cab and she turned it down. She didn't have to drive, but she chose to drive. Not only did the defendant choose to drive after having 11 drinks, but she chose to speed. 16 miles per hour over the speed limit. Through the rain, through the dark. Does that sound reckless to you? Now the defendant wants you to believe that there was a deer in the road that night. Their own accident reconstructionist cannot tell you that's actually true. Taylor Hobson was in the car. She didn't see a deer. The defendant even said she wasn't positive that it was a deer. That's because there was no deer in the road. There was only the defendant and her reckless decision to drink and drive. Members of the jury, you get to decide if the defendant was reckless. You get to decide if the defendant drove under the influence of alcohol intoxication. We've given you the evidence. You know that she was. The defendant made her decisions. Now you have some decisions to make. Nessa Sullivan was 21 years old. 21. She had her entire life ahead of her. She had dreams, aspirations. Now none of those dreams will ever come true. She'll never see her 22nd birthday. It's all because of the defendant's actions. Now, every year on September 24th, instead of celebrating her birthday, Nessa's parents have to throw flowers on her grave. It's all because of the defendant's actions. The defendant was the designated driver. The defendant was the designated driver who drove drunk. And because the defendant was the designated driver who drove drunk, Nessa Sullivan is dead. Find the defendant guilty of driving under the influence. Find the defendant guilty of murder.
May I ask that the picture be taken down for
Taken off of their table?
no, just out of the view of the jury.
No, they're allowed to have it on their table.
May it please the court. You find yourselves at a crossroads, deciding over the life of Miss Danny Dawson. The prosecution would have you believe that Miss Dawson is a monstrous, selfish, murderous individual, but this is absolutely not the case. The loss of a life of a Midland celebrity's daughter. In this case, that celebrity was Miss Ryan Sullivan, a notoriously malicious district attorney, the one representing your state. A series of special circumstances were bound that night. Miss Dawson had to get Vanessa home in only 15 minutes. Miss Ryan Sullivan had set a curfew for her 21-year-old daughter that she had to be home by 1. And for fear of trouble from that mother, she urged Danny that they needed to get home on time. And she also urged that the car needed to be there in the morning. Ms. Dawson was not aware of the fact that she was to be designated driver that night. She only realized this towards the end of the night. Right at the end, after she had been drinking all day. There's no doubt in this courtroom today that Ms. Dawson operated the vehicle under the influence of alcohol. There have been no witnesses to testify to the fact that she was in fact under the legal limit. but the fundamentally flawed nature of Dr. Smith's Intoxilizer 8000 exam has been exposed today by our expert, Dr. Ashley Norton. He has described to you that the set ratio used in the Intoxilizer 8000 is not equivalent for all people, and that this sort of disregard of certain physiological and biological factors could significantly impact the results of that exam. You've also heard about from Leslie Roman, an expert accident reconstructionist and professional engineer, that Ms. Dawson's actions that night were consistent with that of the driver swerving to avoid a suddenly appearing object. Now, whether that object was a deer, a giraffe, a monkey, or a zebra is not the point. The point is that something appeared in that road that night and caused the car to go off the road. Ms. Leslie Roman has also illustrated the gross incompetencies with the prosecution's own accident reconstructionist and field officer. The same field officer that drove Ms. Dawson to the Intoxilizer 8000 exam and supposedly administered a 20-minute observation time. Observing someone in the back of your car while you're driving is not a clinical observation. And the fact that Dr. Smith ignored the observation time of her own procedural requirements shows high disregard for any truth. You've also had a chance to hear from Ms. Dawson herself tonight. You've witnessed who she is as a person. Ms. Dawson is not a miscreant. She's not a monster, and she most certainly is not a murderer. Now, the prosecution has shied away from their burden of proof in this case. They must have proved beyond any reasonable doubt each and every element of the case. And if you can walk out of this courtroom today with one good reason why Ms. Dawson should not be convicted, then you must acquit her. The charges she is facing are DUI and 3 counts of homicide, negligent homicide, manslaughter, and murder. Ms. Dawson realizes that her actions led to the loss of a life, and she should have known the dangers that could have manifested themselves to such an unfortunate end. The defense concedes both the counts of DUI and negligent homicide. Her guilt will follow her through the halls of incarceration, and her guilt will manifest itself in prison. Now, negligent homicide isn't enough for prosecution. They would have you convict her of manslaughter, and you'd do this if you find that her actions were committed recklessly, with a conscious disregard of the risks, acknowledging and electing to ignore those risks. This obviously is not the case. Ms. Dawson was not aware of the dangers of the road. She was not aware of the fact that she was even supposed to be driving that night. There was no premeditation in this act. But even manslaughter isn't enough for prosecution. They would have you convict her of murder, a first-degree felony, and the highest conviction available in a fatal DUI accident. Without purpose or knowing intent, this charge may still be convicted if you find that she acted extremely recklessly, with conscious disregard of substantial and unjustifiable risks, with huge indifference to human life. This is not the case. Miss Dawson merely wanted to grant her friend's birthday wish of making her night magical. This extreme recklessness condition is so abstract that it may only be convicted by a jury of peers. And rightly so. This is such a high burden. The presence of State versus Boris states that the presence of intoxicants in the body is not itself extreme recklessness. And we don't believe that extreme recklessness has been met today. Now, you, the jury, must understand the weight your judgment holds today. You are the arbiter of justice, appointed the hand-picked legal instrument of Midlands over the life of Miss Dawson. If you believe that prosecution has met their burden of proof and proved beyond any reasonable doubt each and every element of the case, if you trust their representations of the case, if you feel compelled to punish Miss Dawson, it is decidedly in your power to do so. But it is also in your power to see beyond the blinding smokescreen of blame and deception and find my defendant guilty of DUI and negligent homicide. Nothing more. Thank you.
Your Honor, before I vote on that, I inquire how much time I have left?
1 minute and 33 seconds.
1 minute and 33 seconds.
Thank you. The first thing opposing counsel did when he got up here to talk to you was try to make you forget all about Vanessa Sullivan, the girl who was murdered by the defendant. That's because he knows what kind of a person the defendant was. She's a person who thinks it's the right thing to do to get behind the wheel after she's had 11 drinks. She thinks it's the right thing to do to speed down the road 16 miles per hour in the rain, through the dark. She's the kind of person who thinks it's okay because she says there was a deer when no one else can corroborate her story. Now, the defense wants you to believe that we have to prove 3 counts of murder, but that's not true. 3 counts of homicide. You can find the defendant guilty of manslaughter, or you can find the defendant guilty of negligent homicide, both of which the defense has already conceded. But members of the jury, what we're asking you to do is find the defendant guilty of murder because she recklessly killed Vanessa Sullivan. Would a law-abiding citizen get behind the wheel when they know they're too drunk to drive? Does that sound reckless to you? The defendant is guilty of driving under the influence. The defendant is guilty of murder. Find them as such.
Thanks, y'all have been doing this longer than I have, so I mean, this is the first round of judging. Okay, procedure now is that, I guess, if y'all want to comment, we can give you comments, or we can just say it away. It's the 4th round, so you're probably exhausted, so it's up to you.
We would love comments, however, Your Honor, the blue ballots have to be out of the room before that happens.
Okay. Okay, so do I carry this down?
All the time keepers are very helpful.
Then I guess I'll take the comments down.
Yeah, you can keep those with you and when you're doing the comments.
Thank you very much. Okay. Good job, guys, especially because you've been doing this all weekend. So you all look, as you should, which is exhausted, but yeah, you're having fun, so that's a good thing. My name's Akila Craig. I am a 3rd-year law student here at Baylor, and my co-judge is...
I'm Spring Thummel. I'm an attorney here in Waco.
I guess I'll go first and then you can, all right. Just some basic comments, I guess, for the whole room. I wrote those down, and then I gave that sheet of paper away, so I'll try to remember from no, they're very easy things. On cross-examination, you're telling your story to the jury. And so the witness is just supposed to be saying yes and no, and just telling your story. So half the time you're not even asking questions, you're just making statements. You were driving that night. You chose to drive drunk. Or you were in the back seat of the car. You didn't have a clear view of what was going on in front. So you're watching the jury and telling that story. The witness is just there to kind of help you tell your story. So remember, your position in the courtroom should be such that you could just be looking at the jury, and the jury isn't really paying attention to the witness because you're telling that story on cross. On direct, that's where you're kind of interacting with the witness, and the witness is talking to the jury. Second thing is a 403 objection is like, it's a good objection, and this is more substantive than anything else, but the thing about 403 is all evidence is prejudicial. That's just a fact. And so you have to have some way of showing that it's more prejudicial than it is probative. And it's substantially more prejudicial than probative. And the whole point is that the jury, when they hear it, is going to make their decision based on something else. So it's not the first objection you want to throw out there. It's always easier to kind of make a relevance objection. And then if they can show that it's, because half the time it's really not that relevant. And so you're better off making that one first and then jumping to the 403 than kind of diving right into 403. Those were kind of the main things I was thinking of for everyone, where your position in the courtroom is really important, and you want to make sure that, oh, right, I remember. We didn't really have a real jury, so it was kind of hard to figure out who your jurors were, but you never want to turn your back on the jury. And if this is your jury panel, standing closer to the podium is always better for you than kind of coming up, because then you're cutting off your last two jurors. And their job is either, all right, I can fall asleep through this trial and then they're never going to go with you, or they're going to be mad that you're turning your back on them. So either one of those, you just don't want to allow that to happen. So make sure that you're always either fronting the jury or you're getting a part of it, but never seeing the back of your head.
Similar, I think everybody could do better on cross at just taking control of the witness a little better. And just for an example, the witness who was the breathalyzer machine expert, she had control the whole time. And even on cross, she was just telling her story like anybody could have been asking her questions. So just, especially on cross, just really